Good afternoon, Deputy Judge President. Please switch on your mic. Good afternoon.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm fine.
Okay, all right. So you don't want to know how I am, but it's okay.
I thought you were tired, so I didn't want to ask the obvious.
I'm full of energy, even if it's
Okay.
the afternoon.
Okay.
Thank you very much, DJP, for making yourself available and coming to this interview. We appreciate it very much. We adopted yesterday selection criteria for candidates for appointment as judges, and part of what the criteria and the guidelines say is that all of us accept that interviews may require that candidates be asked robustly, ask questions robustly, but at the same time we accept that we must always have due regard to the candidate's human dignity. We must show respect and courtesy. So everybody who is here is committed to making sure that, while making sure that questions that need to be asked are asked, and are asked robustly if necessary. At the same time, there is courtesy and respect. So I wanted to share that with you. I'm going to ask you questions. After I've finished, I will give the Judge President the opportunity to ask questions, and then the Premier and the Minister, and thereafter the floor will be open to commissioners. Are you ready for me to start?
Yes, I think I'm ready.
Yes. Please share with the commissioners what your academic qualifications are and where you got them and when you got them.
I got B.Proc and LLB from the University of the North, and I have a diploma in insolvency law and practice from the University of Johannesburg. And I successfully completed a program in disciplinary inquiries at the workplace and a certificate in pension funds law from the University of Pretoria and University of South Africa, respectively. Those are my qualifications. And over and above, I attended short courses offered by the Law Society when I was still a practicing attorney, and various courses offered by SAGE.
Yes. Prior to your appointment as a judge, you practiced as an attorney, is that correct?
Yes.
When were you admitted as an attorney?
In June 1998, on the 11th of June 1998.
And when were you appointed as a judge?
To December 2013, so I practiced for about 15 years.
You practiced for about 15 years?
Yes.
Yes. And then you got appointed as a judge. The diversity of work in your practice, how was it?
I started first as a claims handler at the Road Accident Fund before I managed to secure articles. And I served articles, and thereafter I opened my own law firm in September 1999. And thereafter I opened at the same time a liquidation firm. So I was doing both firms. And I was servicing. I can't say that I was specializing. I was more of a general practitioner. I had a diversity of clients. I had corporates, government institutions, non-governmental institutions, and small businesses and individuals. And I attended also in the insolvency on the administration of insolvent estates.
Okay.
And I was a member of the company's tribunal, and also served on the licensing committee of the Financial Services Board, and as well as a member of the Broadcasting Complaints Commission of South Africa.
Yes. Let me mention also that before I give the JP the opportunity to put questions to you, I will give you a chance of about 15 minutes to enable you to share with the commissioners the challenges that you are aware exist in the division and that need to be addressed, and for you to say how you propose to address them if you were appointed as Judge President. So I'll give you that opportunity in due course. When you were appointed, you were not appointed to this division, you were appointed to another division first, isn't it?
Yes, I was first appointed to the Gauteng Local Division in Johannesburg, and then I moved to Pretoria, and then eventually to Mpumalanga.
Yes. So you have been in Mpumalanga for how long now? In the division?
Let me recall, because I spent some time there before, I think I was transferred in 2019 in October, but before then I had an opportunity to go on circuit, and I acted as a Judge President of Mpumalanga before the appointment. It was whilst the JP was the only permanent judge in Mpumalanga, and he was going on loan leave. Then I was appointed the acting Judge President before I was formally transferred to Mpumalanga.
Yes. Now, when were you appointed as DJP?
In August 2021.
Yes. And how have you found the responsibilities of DJP in the time that you have been DJP?
I don't know now if I'll couple it with the question that you're saying you're going to give me 15 minutes, because I managed to make some observations during that period.
You want to deal with it during that 15 minutes?
Yeah, I think it would be ideal, because that's when I observed some challenges.
That's fine.
Yeah.
That's fine. Now, so you have been DJP for, is it 2 years, more or less?
Yes.
And during the time that you have been in this division, including before you were DJP, you say you have acted as acting JP in the JP's absence, is that correct?
Yes, CJ.
How many times have you acted as JP, if you are able to share that with us?
No, it's only from 29 January 2019 to 11 May.
Okay, that was like two terms or one term and a few months, a few weeks?
I think it's a term and a few months, if I'm not wrong. I stand to be corrected.
Okay. Before you became DJP, did you act as DJP?
I did. I acted for a period of approximately 36 weeks.
Yes.
In 2019, 2020, and before the appointment in 2021.
Yes. Okay, all right. Let me now give you the opportunity to share with the commissioners the challenges that exist in the division and how you would address them if you were appointed as JP.
It will obviously address my vision if I'm appointed as a JP.
Yes, included in that,
Yeah.
you can tell us where the division is now and where you would like to take it if you were appointed.
Okay. My leadership style is inclusive. I envisage to encourage participation and have the system to run optimally. Everyone in the division must appreciate the importance of their role and contribution in making justice accessible. My vision for today, it will be focused on the following: is access to justice, stakeholder relations, modernization, case backlog, insufficient number of judges, transformation, and accommodation for the Middleburg Code. Obviously, we are guided as the judiciary by the norms and standards and the Judicial Code of Conduct I'll use that as a guide in order to ensure accountability and efficiency. Fortunately, in our division, we don't have a serious challenge as far as the civil matters are concerned. We don't have challenges in long reserve judgments and case backlog in civil judgment. And that I'll give credit to our leader because he's so committed and adamant and taking us along in the implementation of case flow management. And as a result, we don't have a challenge in that regard. Unfortunately, as far as criminal law cases are concerned, we have a serious backlog. And this has been worsened by the COVID-19 pandemic and the load shedding, as well as the high level of crime, which leads to an increase in the number of the matters that we already have on our roll. The other issue that's contributing to this, we had 5 circuit courts dealing with criminal cause. Due to the insufficient number of judges, we had to collapse 2 criminal courts. And whilst I mentioned before I lost sight of it, the issue of the load shedding, we have a very serious challenge, especially in Middleburg. We don't have a generator. So we are indebted to the SAPS. We are reliant on their generator. And when we are told it needs repairs, we have to patiently wait. But we have raised this with the Department of Justice, and we have been promised that it's being attended to. On the issue of the case flow, of the case backlog of criminal matters, we had several engagements with the JP, with the Office of the DPP, as well as the legal aid, in order to address the issue and find means and ways to alleviate the backlog. And we addressed this as well as at our PEEC meetings for input from other stakeholders. One of the strategies that we have employed in our division at the moment is, as most of the matters, we have legal aid officials representing the accused persons, is per a court, it's one judge, one same official from the prosecution team, and same official from the legal aid board. So that ensures that if you have one matter collapsing, maybe in the middle of the week or whenever, then you can fast forward the matter. You are not told that the other officials are engaged in other matters. And for this, I'll give credit again to our leader in the division, because this strategy is bearing fruits and we're seeing it being successful. After the collapse of the courts, the strategy at the moment is the JP, at the beginning of each and every term, will write a motivation to the Department of Justice, to the Minister, asking for appointments to deal with the backlog. And it's for some time now we have an additional judge there's a vacant position where we can appoint an acting judge to help us to deal with the matters. And for that we are indebted to the Department of Justice, even if at the moment it's not enough, but at least we're getting something, whilst we're waiting for a permanent solution. On the issue of the insufficient number of judges, our division, like any other division, we were invited to make submission to the Committee on the Rationalization of Areas under the jurisdiction of the divisions of the High Court and Judicial Establishment, which was set up in 2021 under the chairmanship of the former Deputy Chief Justice of South Africa, the Honorable Moseneke. I had the liberty of attending and making the submission with the JP, and one is just looking forward to the finalization of the process, because one is hopeful that at the end of it all, the number of judges in our division will be increased. Because honestly, at the moment, it's a little bit challenging and difficult for us. I can't overemphasize the need for the reopening of all the circuit courts. It's causing a backlog, and we are getting a backlash from the community, especially in matters involving minor children and matters involving gender-based violence. Because if we don't have enough judges, we are not able to finalize matters and deal with them efficiently. So I need not make more motivation at this point, Minister. We really need to take justice to the people. Whilst I'm still on the second course dealing with the criminal codes, the general idea is only to take the criminal matters to the people. I think we must have a shift, there must be a shift in idea, and I firstly need to mention that in our division, the JP has already indicated the desire to have some civil matters to be had at our Mphahlele Circuit Court. But at the moment, because of infrastructural challenges, it's not happening. But one hopes that it will be attended to not long. I think taking division, especially the geographical area that we're covering in our division and the nature of the division that we're serving, we need to take as well, as far as we can, the civil matters to the people and be heard more on circuit court, and not only limit them to Mphahlele Circuit Court. If I'm appointed the JP, I intend to establish mobile courts for each circuit for the issuing of processes and the sitting of the civil courts, which will be informed by the number of civil matters ready to be heard. It can be arranged. One appreciates the financial challenges and the challenges that we are experiencing, but one was thinking if one can have a mobile court where, you know, on certain days, it's maybe in KwaNdebele is the date of issuing, and sometimes people go to Barberton, and then they rotate, and after you'll have to allocate days to make sure that you have a judge to attend to matters in those circuits as well. This will address the plight of the outlying communities who must travel long distances at huge cost just to access the courts, I beg your pardon. I had this idea because recently we have more people appearing in person in our courts. I think it's motivated by, especially in matters involving Rule 46A applications, where in terms of the rule people are, even if when this rule deals with circumstances when banks are about to attach houses, residential properties, and be due to the aftermath of the COVID-19 pandemic, we see the increase in this type of applications. So at least the rule allows people, even if they are not opposing and they are not having legal representatives, just to come to court and put before the court their personal circumstances. So we see an increase of these people. But in reality, if you imagine a person, for instance, traveling by public transport from KwaNdebele coming to Middelburg, by the time he arrives there, I'll be done with my role. And that will defeat the purpose of the rule. So this is what motivated me to think of establishing of the mobile courts. The other related aspect in relation to access to justice is the services offered by the Master of the High Court in our jurisdiction. We are happy and we appreciate that we have the two offices established, one in Bombela and one in Middelburg. I had an opportunity, whilst we were having challenges, to engage with the Chief Master to discuss the need to offer the full complement. As it is, people in Mpumalanga are not receiving the full complement. For instance, there are challenges with the Guardians Fund, and that's a very important component that they have to serve because it's for the benefit of the indigent. It doesn't help for people to still travel to Pretoria to access. So we have agreed with the Office of the Master's Office that they will give us regular reports about the developments on how far are they and on the rollout of the services that they are going to offer in our jurisdiction. And when it comes to the issue, again, of the litigants who appear in person, the other issue that's a barrier for access to justice is about the language. Most of these people doesn't understand the language of record. And it's only fortunate when they find a person who understands their language as a presiding judge when they appear, because then you are able to engage them. So our thinking that if appointed, I intend to establish a help desk that will be manned by a multilingual official who's independent from the Office of the Registrar, who will be able to assist. Because sometimes some issues, people just have to be pointed sometimes to a right direction, like for pro bono services or to the magistrate courts, whatever service that they want. But at the end of the day, those lay litigants must leave the court being satisfied of the service that they receive from our courts. On the stakeholder relations, I'm indebted to the Judge President for having allowed me to chair the PEC, the Provincial Efficiency Enhancement Committee. I have chairing the meetings for some time now, even before my permanent appointment as the Deputy Judge President. The committee is mandated to enhance performance and outcomes in the delivery of quality of service. We had a very effective committee, and we were meeting physically. Unfortunately, our performance was affected by the COVID-19 pandemic, and as a result, when we tried visual, there were load shedding issues which resulted into network issues. So our meetings were affected. And when you have to postpone meetings where you're meeting different stakeholders, it sometimes poses a challenge. But I'm happy to announce that recently we are back on track, even if there are some members who are not yet back. We wrote letters to them just to remind them to come back to participate and make them to appreciate their role in the committee. Therefore, I undertake to ensure its optimum functioning.
We have gone past the 15 minutes, but I'll give you 5 minutes to wrap up.
Okay, over and above the PEC, I had an opportunity to engage some stakeholders outside the meetings, depending on the nature of the challenge that we had. Like I had a meeting with the Department of Health where we had a problem in the province. We didn't have a psychiatrist to evaluate and assist in criminal matters. And with the approval and direction of the JP, I managed to form the Provincial Judicial Forum, where I have meetings with the Regional Court President and the Chief Magistrate. It's not long that we have started that, and it had its own challenge, but I had a buy-in for them, and they are very cooperating. And one is intending to intensify and making sure that it's going to operate to its full optimum. And on internal stakeholders, I intend to contribute to the training of the staff to make sure that they appreciate what we intend to achieve. And on the issue of modernization, some judges in our province attended the training offered by Judge Mulambo. We're still waiting eagerly for the rollout of case online and court online. I think I'll just end there then. And the issues of transformation. Yeah.
Okay, no, thank you very much, DJP. I asked the previous candidates whether there is any backlog in the division. I just want to put that question to you. I see you talked about backlog. Case backlog.
Yes, criminal matters we do.
How serious is it?
It's very serious.
Fairly serious.
I'm not proud to announce that we have the issue of the collapse of the two circuit courts.
Yeah.
Yeah, and the office hours as well.
Yeah.
The court hours affected by the load shedding. Remember, the circuit courts are in the magistrate courts, and you find there where there are no generators.
On the civil side?
On the civil side, we're doing well since the implementation of the judicial case management.
Yes. Okay, thank you. I now give the Judge President the opportunity to put questions. Judge President.
Before, can I be just proactive before we move on? There's an issue that I just wanted to just to be proactive and put it on the before the commission.
Yeah.
I wrote a note to the commission regarding an issue that happened subsequent to me having submitted my application.
Yes. You want to talk about it?
Yes, maybe just briefly.
Yeah, talk
because
about it.
I've written a note and explaining, and at the end why I believe it doesn't have an effect on the issue doesn't have an effect on my capability to be appointed as such.
Yes, deal with it.
Yeah. there were summons, civil summons issued against me without notice being, consent being obtained from the judge president. And I got hint of it. And when the attorneys advised, the attorneys for the plaintiff, then after some engagement, they withdrew the summons against me and the other two liquidators, but the other defendants where the action was not withdrawn against them. And before they withdrew against us, we issued an exception, and the other parties as well did an exception. After it was withdrawn, then we left it. Then they approached the JP for a consent, and through my attorneys, I made representations that one, this matter, whatever caused the claim happened in 2005 whilst I was practicing, some 17 years ago. And it has prescribed, and secondly, and the main thing is that there's no merits to the claim. In the meantime, and the JP granted them, eventually he granted them a consent, and I accepted his decision. Whilst waiting for their papers, because according to them, they stated in their letter that according to them, the claim was prescribing on the 10th of November, 2022. And my view was it prescribed in 2008, but they insisted that it was 10 November, 2022. Then I waited for the summons, nothing was forthcoming until the end of November. And before the end of November, the other parties proceeded with the exception, and Moshwana AJ in October set aside the particulars of claim, and they had a period of 30 days to amend their papers, and they did nothing. So that ran flat. Yeah. And I waited until the last day. I submitted my application form, and that's why I didn't indicate anything about the matter in my papers, because I thought sense prevailed after they considered the exception of Moshwana AJ, and after the 10th of November that is stated in their letter has come and gone. So according to me, it has prescribed. So after that, on the 2nd of December, they issued the papers, and on the 12th of December, they served me with the papers.
Yes.
And I'm of the considered view that their claim has prescribed, taking into account.
It's a civil claim.
Yeah, it's a civil claim. On their own version, it prescribed on the 10th of November, and we have the exception on the same basis that we are defending our matter. Moshwana AJ upheld the exception.
Is it a claim based on an allegation that while you were practicing as an attorney, there is something you didn't do properly, or what?
It's a claim that I was a liquidator. We allowed people to mine illegally. We as liquidators, we rely on documents that are issued by the Department of Mineral and Energy. So the department is the one who gave us permission, even in the sale, because we sold it in the same year, in 2005. We got the consent from the department. It's the department who gave us the information that the company that was in liquidation was the rightful miner.
Okay, I know that's all right. JP?
Thank you so much, CJ. This issue that you have told us about now, you will recall that it is something that is worrying me very deeply. And you're aware that on the 28th of January 2023, that is 2 days before the shortlisting, I wrote a letter to you. Fortunately, you have shared that letter together with your response there to the members. I'm going to leave that to the members of a commission within their wisdom to deal with that issue. But you know that it is an issue that is deeply worrying me. Now, let us go where we need to go. You are aware that even before you were interviewed for the position of the DJP, I started actually offloading, almost like doing some sort of handover. And that has continued until today, am I right?
Yes, JP.
Many things that are supposed to be done by the head of court is now done by your office, am I right?
Yes, JP.
In
The
two-
ones that are listed.
Yes,
No.
the ones that you have listed. And many meetings with stakeholders that I attended to, I have taken you along, particularly with regard to some of the meetings with the stakeholders. You are also aware that I have engaged and I've been engaging Judge Mphahlele. Even the post was advertised to help me in Mpumalanga before the return of Judge Sheila. I'm not sure if you're aware of that.
No, I wasn't aware. I only became aware in that meeting with the stakeholders, with the NDPP.
Yes. And you will recall that on the 1st of February, I wrote a letter to you and Judge Mphahlele, where I've indicated and invited every one of you to approach my office to know about the ins and outs of the working of the office of the Judge President, other than some of the meetings that I have allocated to you. You're aware of that?
Yes.
Yes. And I'm not you know that since that time, Judge Sheila has been part of us in terms of the engagement with the stakeholders and some of the meetings that the office is normally holding with the staff. Am I right?
Yes, he attended the meeting.
Yes. Now, you have also spoken about the division doing well in terms of the backlog relating to the civil role. Am I right?
Yes, JP.
You know that since September, almost like on a daily basis, I've been in court implementing the judicial case management.
Yes, JP.
And that has cut off the civil trial role by almost 60%, because many matters, especially with RAF, are resolved during the first and or the second judicial case management.
Yes, JP.
You're aware of that?
Yes, JP.
And all the colleagues are participating in that respect.
Yes.
Yes. Now, you may not be aware of this. The waiting period, if I was to certify a matter trial ready, because almost our trial role has collapsed, because in each and every case management conference, RAF is there. We have done it in such a way that RAF attorneys will always be in our court. You are aware of that?
Yes, JP.
And today we actually had about 30 judicial case management matters in Middelburg. I'm not sure if you're aware that tomorrow I'll be presiding over another 30 matters which we have pulled in Middelburg. You're aware of that?
No, I wasn't aware. But
Yes.
tomorrow.
Now, the waiting period, if a matter was to be certified today, trial ready, the waiting period is about 3 weeks or 4 weeks. Judge Mphahlele said 3 months, but it is actually 3 to 4 weeks waiting period. You are aware of that. If I was to certify a matter trial ready today, either the 8th week or the 9th week, if the parties are ready, they will be on trial. You are aware of that?
Yes, JP.
Okay. That is all. Thank you so much.
Thank, Thank you, JP. Premier, I now give you the opportunity. Premier, are you there? Oh, it looks like there is a complete,
Thank you.
oh, okay.
Yes, I am. Thank you very much. There's no shading.
Oh, okay, all
I
right.
was saying, can you hear me?
No, we can hear
Can you
you.
hear me?
We can see you as well. You can go ahead. Oh, you were frozen for a few seconds.
Okay. Okay, thank you very much, and good evening to just okay. Now I'll try because I'm in a darkness now. I'm just trying to organize the lights. Just the first question that I want to ask that she has checked the PEEC on a number of occasions when she was delegated by JP. And I see that she only has 2 reserved judgments, which to me, even though it is not completely, we must commend that considering the position and the responsibilities you are holding and your active participation in the African Women Lawyers Association, just to cite the few, how has that additional responsibilities impacted on your caseload? That would be my first question.
Yeah, you can answer, DJP.
On the matters that I have, the matters allocated to myself, or caseload of the whole judge, I didn't, because it keeps on breaking, I didn't
Oh, you
get
didn't hear the question?
Yeah, clearly.
Okay, Premier, would you repeat your question? Just ask one question at a time. Premier, are you there? Can you hear me?
Yes. Now, I was saying that given the work that she has been doing over and above the responsibilities in terms of the comment, can you hear me? I can hear
Yes,
you.
Yes,
yes,
we
now
can
I
hear
can
you.
hear clearly.
Hello? Chief Justice, can you hear me?
Yes, we can hear you, Premier.
Okay. Now, I was saying that given the extra okay. I was saying, Chief Justice, given the extra responsibilities that she has been given over and above the core mandate that she has to undertake as the Deputy Judge President. And she has, of course, indicated that amongst those would be sharing of the PEEC, of which she was delegated by JP to do as such, and amongst the other responsibilities that is participant in progressive legal formation, such as the South African Women Lawyers Association, just to mention one. And considering the workload that she has. Now, the question that I'm posing to her is that how has the additional responsibilities impacted on her caseload? And I also see that
Premier, are you asking how her additional responsibilities as DJP, how they have impacted on what caseload?
Yeah. I think I can answer.
Are you there, Premier? I wonder whether there isn't another way. I'm wondering whether she can phone somebody here who can then who can then tell us what the question is. Premier? Yeah, I think maybe let's go to other. Let's ask other. I'll continue, and later on she might be in a better position.
Chief Justice, at least this question, she completed this one. And
Well,
we all
if you heard it, please tell it to the
No,
candidate.
even the candidate had the
Yeah,
question.
did you hear it, DJP?
Yes, I think the activities that she specifically mentioned, I have to clarify that the PEEC, we only hold a meeting once during the recess. And the South African Women Lawyers Association is an organization of legal practitioners. I don't attend their meetings. It's only upon invitation when they are having seminars or workshops. So it's not like things that I attend on a daily basis, and they don't have much impact on my workload.
Yes. Okay, Premier, if you can hear me, we are going to proceed. In the meantime, try and find a place that will not have network challenges. So we will give you a chance later on. But in the meantime, I will go ahead and then we'll come back to you in due course. Minister?
Okay.
Okay.
Can you hear me?
We can hear you now. Okay, let me give you a
Okay.
chance, but if there is a problem again, we'll move on and then come back to you later on when maybe you might not have those challenges. Continue.
Okay.
Continue.
Yes. I think I'm a bit disadvantaged. She probably might have not heard the question that was posed before her, and I heard her response just towards the end of it. But then I just want to move on to the second question that I wanted to ask, which is in line with Section 174, subsection 2 of the Constitution, which places an obligation upon the judicial officers to ensure that the judiciary is transformed and reflect the racial and gender dynamics of our country. In your time in the judiciary, how have you contributed to the transformation of the judiciary? And if you were to be appointed, how will you advance the need to transform the judiciary?
DJP?
The contribution that I've done is, like I mentioned, when invited, where legal practitioners are, like I mentioned in my profile, that the BLA, when they're having their trainings in Bombela, when they're inviting, I participate for the empowerment. And even Saula, when I'm invited, and the legal practitioners. And when the JP invite me to submit names of maybe potential candidates, I try to nominate the names of women. But what the House must appreciate is that in our division, especially in Middelburg, you only have one position of an acting judge. And for me, transformation is not only about that, it's also transforming even the people that we are working with, for them to appreciate what the judiciary aims to achieve. And that's the other part that one is busy on as well, for us to have a common goal and to transform the whole system, to make it accessible to the community and be user-friendly.
No, thank you very much for the response, Deputy Judge President, and thank you very much for an opportunity, CJ.
Thank you very much, Premier. Minister?
Thank you very much, CJ, and good evening, Deputy Judge President. And
Good evening, Minister.
You have indicated in your vision that you will also look at putting some mobile courts and all that. And I know one of the biggest challenges the court is facing is the maintenance of the existing infrastructure, particularly the new building, and the other circuit courts. What do you see your role as a JP playing in engaging the stakeholders to ensure the maintenance, the fixing of the infrastructure, including how you are going to deal with these issues of the mobile courts, which will also need these other stakeholders? What do you envisage the role of JP being in that process?
Fortunately, we have already started in our division under the leadership of the JP. We are having regular meetings with the stakeholders. I stand to be corrected by the JP. I think it's almost monthly. We get regular reports. We are engaging the Provincial Department of Justice and DPWI and all the stakeholders. We're trying to put pressure on them, and we're meeting, and that's how I intend to intensify. There's an initiative that's working for us, even if sometimes progress is very slow, but slowly we're getting there.
Thank you, CJ.
Thank you, Minister. Commissioner Nyambi?
Thank you, CJ. Good evening, Deputy Judge President Mphahlele.
Good evening, Commissioner Nyambi.
It's only one question from my side. The last time in 2021, April, when you were interviewed to be a DJP, as it's also a leadership position, I must indicate that you interviewed well and you made some commitments about issues. To remind you, maybe one or two of those. Minister asked you about the challenges that is experienced by the Master's Office. Some of us ask about the challenges of the division of Mpumalanga. And out of all those commitments, probably if you can single out what we have done, because currently you are a DJP, in terms of making sure that you provide leadership, and if you can be given the opportunity to be the JP, you can take the division to greater heights. So in short, progress report out of those commitments we have made in 2021.
I haven't prepared my progress report, but what comes to mind now is about the issue of the master, which I think we have made progress, like I've already indicated, and it's work in progress. And the second one, there are two that comes to mind immediately. The second one is about the user-friendly of the court, especially in Middelburg. Remember, it was not accessible to disabled people. So in our new old court, it's an old court, but we call it new, we had phases. So I undertook that the phase that we're in, it will be made accessible. But I'm very sad to announce that it hasn't been attended to. But in these stakeholder meetings, I keep on reminding them and I get an undertaking. But fortunately, in the third phase that we are about to occupy not long, it's user-friendly. People, you can use a wheelchair so far. So those are the two that I can quickly remember.
Thank you, DJP. Thank you, CJ.
Thank you, Commissioner. Commissioner Marumoahai.
Thank you very much, CJ. Good evening, Judge.
Good evening, Commissioner Marumagai.
I want to ask you a question which generally troubles me, and perhaps maybe I'm asking it to you because you are here, but it's not necessarily intended for you. It is a question that deals with how judges write their judgments. And I understand the fact that at the High Court level, judges are under pressure, they have many matters, and sometimes it is not easy to consider seriously all the judgments that they are writing. Sometimes they are pressured to release judgments. But nonetheless, the concern remains that as law lecturers, we use judgments to teach. And if we do not do that and we produce candidates which are not well suited for practice, we get criticized. And that is the context within which I'm asking this question. There is a judgment that you wrote. If you could just bear with me just for a second. It is, the parties are Invest Tech, Investec Bank Limited versus Mildred Tsakani Chauke. It was delivered on the 7th of December 2021. Do you remember that judgment? It dealt with, in this judgment you were confirming.
Sequestration also.
It dealt with sequestration, yes.
Yeah, I have an idea.
Yes. No, now I'm not going to ask you about the specific in terms of the facts, but I was quite intrigued when I was reading the judgment. And when I look at paragraph 24 and paragraph 36 of that judgment, it gives me an impression that you have this thing called sequestration, and in order for a person to be sequestrated, there is this requirement, advantage to creditors. And in the judgment, you don't necessarily deal with the requirements for sequestration. And it is not particularly clear to me as to what act of insolvency in Section 8 was applicable in the judgment. But most importantly, and what is concerning to me is, you don't deal with, assuming that you're not dealing with voluntary surrender and you're dealing with compulsory sequestration, it doesn't appear from the judgment that you deal with the procedural and substantive requirements, Section 4 and 6 respectively, of compulsory sequestration. And I'm saying this on the backdrop of what I said, that we use these judgments to teach. So when I'm confronted with a judgment like this, which does not necessarily assist me to understand the context within which the law that is applied comes from, I'm not sure, do you have a comment on that?
I want to comment, but I'm thinking.
The judgment is part of your PEG from page 62, if I'm not, page 63. It is fact orientated, so it deals much with the facts, but it's not really that rich in the law. I'm not sure if, it's not a criticism, and I'm not criticizing you. I just want to get your sense of the point that I'm putting across.
Yeah. Page 63 and paragraph?
From page 63, the entire judgment, but I was really concerned about paragraph 24 and 36. Paragraph 36 in particular says that, look, this thing, whatever, because advantage to creditors has been proven. So it gives a sense as if that is the requirement.
No,
for.
I'm sorry, 63 is the point law
No.
one. I think maybe the numbering here. 63 is the point law judgment. Oh, okay.
On the PEG
No,
that I have,
I was looking upwards. I'm sorry.
yes, on the PEG that I have, page 63, that's the first page of the judgment, Investec
Oh,
Bank
yes.
Limited versus Mildred Tsakani Chauke.
Yes.
Yes.
Yes, the paragraphs that you're referring me to.
Oh, the first paragraph is paragraph 24. You say the respondent maintained that she had made arrangements with other creditors and it would not be for the benefit of creditors should she be sequestrated.
Yeah.
And that is quite right. That's nothing wrong with that. I'm just saying it gives an impression, the entire judgment actually, it gives an impression that this is the requirement that one has to comply with.
Yes, it
It is a requirement,
Yeah, it
yes,
is
but it's
a
not the only,
requirement.
it's not the only
Yeah,
requirement.
Yeah, it's not the only requirement.
But your judgment gives an impression that this is the only requirement, at least from the way I read it.
Commissioner,
No, if you go through it, I dealt with the issue that he was not able to pay the debts that he was called when I called upon to pay. I dealt with the issue.
Commissioner, can I put this question in a different way?
Yes, please assist me.
Yeah.
Perhaps maybe I'm not putting it correctly.
Yeah. As I understand the Commissioner's concern, is that your judgment dealing with sequestration would have been expected to indicate what the legal requirements are for you to grant a sequestration order. And when you read the judgment, it seemed to refer to only one requirement, and that gave the impression that that's the only requirement, which I think he's saying that's not correct. And he's concerned about that because when he teaches law students and when they read this judgment, they might think this is the only requirement, whereas he's teaching them there are other requirements. I hope I have not misrepresented you.
No, the
trust.
the rephrasing is correct. Perhaps maybe if I can assist the judge. The section 4 and section 6 of the Insolvency Act provides both the procedural
Yes.
and the substantive requirements. And when one deals with benefit of creditors, that is one of the substantive requirements. There are two others. You do deal with them factually without outlining them. But I'm saying the way in which, it's not a criticism. Don't take this as a criticism.
Yeah.
I'm just putting across a general concern that I have with a lot of judges. That reading your judgment, you might well be right in your judgment, but I'm just saying, reading your judgment, it gives an impression that there is only one requirement that one needs to fulfill, especially for compulsory sequestration.
Okay. I take the concern, but I have to say that if you go, I admit that I did not mention the requirements, but I dealt with the requirements. To the extent that I mentioned that demand was made, and I found that he failed to show that she was in a position to pay, so I dealt with them without mentioning them. But I take what you have mentioned and your concerns. Thank you.
I will leave it there, Chief Justice.
Thank you, Commissioner. Commissioner Shabangumdawe, I have two more, and then I go to the virtual, and I will see if there are others, but those are the ones I have at the moment. Commissioner Shabangumdawe.
Thank you, CJ. Good evening, DJP.
Good evening, Commissioner.
How are you?
I'm fine, yourself.
Yeah, it has been a long day. DJP, the candidate before you indicated to the commissioners that there's a challenge in the division where legal practitioners are complaining about the practice directives. And he also indicated that, I'll just put it this way, nothing has been done thus far to attend to this challenge. Should you be,
I'm sorry, Commissioner. I'm not sure that that's a fair reflection of what he said.
what he said they are not engaging.
Yeah, but he didn't say
They-
that nothing is being done.
Okay, I'll rephrase it. They are not engaging.
Okay.
So you, DJP, as a leader of that division as well, can you share with us maybe as to what is it that has been done thus far to address this challenge? Because from what I believe in is that the legal practitioners are also very important stakeholders in the division, where you need to get a buy-in from them for whatever that, particularly with regard to the practice directives. And what is it that you will do going forward if appointed as a judge president to deal with this challenge?
Through you, CJ. I've noted on the comments by the GCP that the issue was raised as well. When practice directives are issued, after they are being issued, and I don't know, this was not our first set. Remember, we are the new babies on the block, so to say. The first one we issued, there was an invitation, I remember, to the practitioners, the locals, to comment. And these ones, I think you were invited to comment, but we were already, it's like we were implementing and then you were welcome to comment. The only practitioners who engaged is the practitioners in Middelburg, and we had a workshop with them, and after that, they were happy. And I need to mention that when chairing the PEEC, the representatives of the legal profession and the LPC, they informed the meeting that they are happy with their engagement with us. The issue of the practice directive was never raised. The first time I saw the concern, it was in the comments. And reflecting on it, I thought, because now, as you know, in Mpumalanga, we promoting appearances. We hear people, and most of the people who are appearing before us are coming from Johannesburg and Pretoria. I thought to myself that maybe when we consulted, when the invitation went out for comment and engagement, it did not reach the people who are regularly appearing in our court. And the practice directives are not cast in stone, and the office of the JP is open for engagement. And what I think can be done, the other suggestion that I have, is that we have a liaison committee with the PLC, that we have that committee where we will be liaising with on an ongoing basis. And we welcome feedback, and we saw what's noted in the comment section, and we'll go back and reflect.
Thank you, CJ. I've got my last question today.
And if I may add, if you remember, Commissioner, you were present at the meeting of Saula when I was invited in August to celebrate the Women's Month. I was a guest speaker there, and I made an invitation to the female practitioners there that I'm willing to use my weekend time to come and discuss with them the implementation of the practice directive, and I'm still waiting for the invitation.
Okay.
Commissioner, you remember, one, unless there is strong motivation. One question, unless you strongly motivate to
I
me.
think this one yeah.
What is the motivation?
It deals with transformation, CJ.
Why can't we do without it and move on?
I can't leave this one out, CJ.
But what is the
It's very
motivation?
short. It needs
Ask
only
quickly,
one answer.
okay?
Thank you, CJ. DJP, there's this saying that the gender transformation of the judiciary will strengthen South African's judiciary, right?
Yeah.
You as a woman and also a leader in the judiciary, have you ever invited women from Mpumalanga to come and act, so to mentor her, at least to be on the very same chair that you are sitting on in future?
I have to confess, mentoring I done, but it's people in Gauteng. In Mpumalanga, I haven't done it as yet, but they are appearing in the code there. So they are serving the people of Mpumalanga.
And they want to hear DJP as to, is there any chance that one day they will be considered to act? Because we really, women from Mpumalanga to come and act.
Yes, we have in Bombela, we have, I don't want to call the first name. I forgot the surname because I'm used to call her on the first basis.
Of course,
We
you
have
consider
to-
them because you are
Yeah,
not
we are-
excluding them, isn't it?
No, we are not excluding them.
Yes, you will consider them.
Yeah, we will consider them. We are, they are acting.
Yes.
We have one on the roll now.
Okay.
Thank
I have Commissioner Dodovu, Commissioner Matolo Lepu, Commissioner Singh, Commissioner Mphahlele. Commissioner Dodovu.
Thank you very much,
Let me
CJ.
just say before you proceed, Commissioner Dodovu, we are at 7:15. I would like us to see if we can finish at 7 with this candidate. Okay?
Yes.
All right.
No, mine is
Anyone
very,
who-
very short.
who doesn't feel strongly about a certain question, please allow us to finish. Only those where you read. Now I'm talking about those that I've got here. Okay, all right.
Okay. Yes. Managing tensions and conflicts is one of the key responsibilities of leadership. And conflict is everywhere, and I can see with my 4-year experience in this commission that there is tension and conflict too within the judiciary. In your own experience as a leader, how do you manage conflict? Or how will in the future, if you are considered for this position, ensure that you manage conflict and tension in your division in a way that will ensure that your division is successful and it does what is expected of it?
It depends on the cause of the tension and the conflict. I only think that you saying you have observed tension and conflict, but I want to believe that judges, as far as emotional intelligence is concerned, they must be at the top of it. As adults, who have these enormous responsibilities. But if there's tension, as a leader, you must intervene just to harmonize. And it will, like I say, it will depend on the nature and the cause of the tension. I wonder if
CJ is okay, in the interest of time.
Yeah.
Yes, okay, thank you. Commissioner Matolo Lepu.
Thank you, CJ. Mine is just a comment. I mean, in your vision, you indicated that to encourage access to justice in the court, you are going to maybe recommend that somebody outside from the registrar's office just to assist members at courts guide members of the public. What I just wanted to find out, have you considered, especially because Mpumalanga is a vast province, have you considered working with community-based organizations? Because most of them are trained paralegals. Because we are doing it in Gauteng, we can still do it. We are supporting it as the LPC in Gauteng, we are supporting it in the Free State. Maybe we can approach the LPC to assist in that regard. I just wanted to comment on that.
I'm really grateful for the information, and one is willing to engage the LPC in that regard.
Thank you, Commissioner. Commissioner Singh?
Thank you very much indeed, Chief Justice, and good evening to Judge Mphahlele. I just want to know, going back to 2021, whether you've had any run-ins with attorney Mr. Sheikh Omar. There were some complaints then, and I trust you have dealt with them. And secondly, to appreciate your positivity, because in 2021 I asked you specifically, do you have any intentions or aspirations to be the JP of Mpumalanga one day? That was 2 years ago, and your answer was, I do, like in a marriage ceremony. So I'm very glad that you have availed yourself for this particular post. But just a question on Attorney Sheikh Omar. Thank you.
Maybe I didn't get, have I ever encountered him after? Is that the question?
Yes.
No, no, I haven't encountered him thereafter.
Thank you, that's an answer. Because he complained bitterly the last time, but you dealt with it then. Thank you.
Thank you, Commissioner Singh. Commissioner Mphahlele?
Thank you, Chief Justice. Good evening, DJP Mphahlele.
Good evening, Commissioner Singh.
Mphahlele.
Oh, Pile, I'm sorry. You're my thousand apologies.
No, that's fine. Yeah. Can I say to you, I couldn't help but notice that the 3 judgments that you attach to your application, that none of them are reported judgments. And in fact, it goes a bit further than that, because the one adverse comment raised by the GCB is that you do not appear to have any reported judgments in your 10 years as a sitting judge. Now, given that we would look to the leader of the court as providing not only administrative leadership, but also intellectual leadership within the court, what do we make of the fact that you don't have any reported judgments?
Firstly, I'm looking through my papers. I have one that I didn't even mark reportable. I was still in Gauteng, dealing with the jurisdiction of Mpumalanga. But on that aspect, I acknowledge, but it would be, for lack of a better word, not proper to assess me on the number of judgments that have been reported. Because one has to look at the judgments that are produced, the type of judgments that are produced. And I don't have authority over the people who decide what to report or not to report. And what's comforting is that all the judgments are available on SAFLI for the broader community.
Am I allowed to follow up?
Follow up,
It's just a
okay.
factual thing.
Yeah.
The difficulty with that explanation, DJP, is that obviously as a judge, you have control about whether or not you indicate if your judgment is of interest to other judges. And in all of the judgments that you've put up, which I'm assuming is the best of your lot, I mean, you've put up your best samples. In all of those, you've indicated that they are not of interest to other judges.
Not that I want to be defensive, but what I can mention is maybe one is modest. I can mention judgments like the ones that I mentioned in my PEG, a judgment where I had to deal with a lacune in the Poker Act when dealing with the attachment of the accused person's assets, and one judgment where I had to deal with the relations between the district courts and the regional courts, and that judgment was even discussed in the Rebus, the magazine for attorneys. Maybe one is modest in not indicating, and I take take responsibility for that.
Thank you, DJP. Thank you, Chief Justice.
Thank you.
Thank you. We have come to the end of this interview. Thank you once again, DJP, for availing yourself for this interview. You are now excused.
Thank you for having me this late.